For Creamer Media's Polity, I'm Niel Coertse. MDA Consulting's Niel Coertse joins me in studio to discuss alternative dispute resolution in construction contracts and MDA's program, which is set to be launched at the University of Pretoria next year. Welcome, Niel.
Thank you.
Niel, please give us a brief description of the construction and engineering law field in South Africa.
It's a very dynamic field in South Africa. If you look at any construction contract, whether you're looking at an NEC contract or you're looking at a FIDIC or, our own homegrown ones, JBCC and GCC contracts, you've got a whole mix of various legal disciplines in there, not only legal disciplines, but you've got your technical requirements that are addressed in there, or potential technical requirements or risks, your defects and that kind of thing. And it's a whole host of issues, for example, like intellectual property. If there's a design involved, process flows or whatever, there's big intellectual property in these contracts. So it deals with that. It deals with legislation. You've got implied legislation in there, for example, your Conventional Penalties Act, how that deals with delay damages by an employer against a contractor, for example. You've got Mine Health and Safety Act. You've got your Labour Relations Act. You've got law of damages that are applicable there. It's a very, very dynamic contract that you're busy working with all the time. It also deals with change in a construction project. How do you deal with variations? How do you deal with extensions of time? How do you deal with additional payments? So it's a very dynamic field. Also, it deals with finance. Not just finance, but firstly, how are you going to get paid? So, you need to know a bit about your interest rates, exchange rates. If there's goods and equipment purchased from overseas, how is that going to get paid? So there's a whole host of factors in there. So that's just a little bit about a construction contract, the dynamics involved there. But then if you look at the construction field in South Africa, I think in South Africa, if you compare it to the UK, I think you could say almost like an infancy stage in South Africa. The UK, for example, has your technology and construction courts, which is a very specialist court that deals only with technology and construction law issues. We don't have any of that in South Africa. What we're trying to do is import some of those best practices, so to speak, into our industry here. You don't have any programs in South Africa to actually educate potential construction lawyers on construction law issues. So that's if you go to the UK, you'll have an MSc in construction law that you'll be able to do. Where in South Africa, you go and study a general LLB degree. It makes you a specialist in anything, and you end up in the field by chance. So it's not really a specific choice that you can go and study, but you end up there through working through the right departments or wherever at your firm, or end up there by word of mouth, end up at an engineering company. So yeah, I think that's, in my view, the construction industry in South Africa. If you look at the body of knowledge that we have available to us, we have a very limited body of knowledge, especially in terms of court judgments. Yes, there have been quite a few court judgments in South Africa on specific construction-related issues, but there's nothing, if you look at the body of knowledge in the UK, their law and how they've developed it, it's in an infancy stage, I think, in South Africa. So the problem is, with our South African courts, they're not bound by the decisions of the UK or decisions that you get from Singapore or decisions from Australia. They can use that merely as persuasive influence to interpret a judgment. The starting point here is that our courts are bound by previous decisions of other courts, and if there's a problem and they can't find guidance because there's a lack of precedent for it, they have to go elsewhere to find the appropriate judgment that's made to interpret the situation or give resolution on the dispute. So,
okay, great. Can you take us through alternative dispute resolution in construction contracts?
Well, a dispute resolution has two main forms. It has your traditional form, which is litigation. You'll sue or be sued in a High Court of South Africa. And then you've got your alternative dispute resolution mechanisms. The only one that's governed by legislation is arbitration. It's governed by the Arbitration Act. You've got other dispute resolution mechanisms or alternative dispute resolution mechanisms such as mediation, adjudication, and now you've got your arbitration as well. So it's not governed by any legislation in South Africa. Your adjudication, there's been 1 or 2 High Court judgments that a court has decided that where the parties have agreed that their dispute must be adjudicated on by an external third party, the court will hold them bound by that decision. Whereas arbitration, if you get an arbitrator's award, you can enforce that as a High Court order. For example, if you get an adjudicator's decision, it's enforceable, but you actually have to go and apply physically to the High Court to have that made an order of court to enforce it. The court won't interfere in the correctness of the decision, but it will only when there's fraud or misrepresentation or serious bias on the part of the adjudicator. That's when a court will interfere in that, but only if it's raised by an aggrieved party, for example. So that's alternative dispute resolution. Your 2 main branches, your traditional and your alternative. Dispute resolution.
Thanks. Lastly, can you please tell us more about MDA's program in construction adjudication?
Well, this program, we had a look at the, for lack of a better word, I think, education in our country for adjudicators. We teamed up with the University of Pretoria, and we've going to launch this program in February 2013, which is an 8-month program. It's the first of its kind in South Africa to actually educate legal professionals or engineering professionals on the basics of an introduction to South African law, and then it focuses specifically on engineering and construction law areas, some of which I've mentioned earlier. Your engineer's role, it'll look at that. It'll look at for example, your traditional construction disputes, how that gets resolved. So it's really try and educate potential adjudicators on South African law and specifically construction-related disputes. The reason why we're doing it as well is because it's imminent that the CIDB is going to enact legislation where it makes adjudication a statutory requirement to resolve any disputes. If your construction contract doesn't provide for appropriate dispute resolution mechanisms, you have to follow the CIDB's guidelines and their recommendation how to solve these disputes. So once that is in place and once that's enforceable as law, we hope to have a body of adjudicators ready to actually comply with it. And I think it's a very ripe field in South Africa. There's no qualified adjudicators in South Africa. We've got a few arbitrators, but there's no adjudication in place. Adjudication is really the best way to describe it, is a rough and ready kind of justice. I think the most basic principle that has to be adhered to is to follow the rules of natural justice, which is to hear the other party. The aim of it is really to deal with a construction dispute as and when it arises, and you don't have the luxury of time where you'll have, for example, with an arbitration or litigation to go to court. So as a dispute arises, an adjudicator will be on board, for example. He'll be nominated in the contract as the adjudicator, and the dispute gets referred to him and the parties can get on with the work and he'll make a decision. So it's to really eliminate construction or project hangovers where the project is finished, and we can see it now in South Africa where the Gautrain's finished, the soccer stadiums are finished, and the litigation and the disputes are continuing well after that. So this tries to limit it to the period where the construction or the project takes place. So
okay, Thanks, Niel.
Thank you.
That was MDA Consulting's Niel Coertse discussing alternative dispute resolution in construction contracts and MDA's program to be launched next year.